Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend, special guest, Russ Cook with Russ Cook & Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney, one of a few, and all he does is estate planning. So when you get into taxes, and not just your basics, we're talking about some basics today of that, the 5 essential documents, the foundational planning, the things that would appeal to most of you listening out there. But there's also other ones that we're talking about, or that Russ deals with, I should say, advanced planning. You get into charitable foundations, charitable remainder trust, a lot of advanced technique. We'll be talking about those in future shows as well, maybe if we have time a little bit today. But one of the things first, coming back to where we left off, this is the difference between a will and a trust. When we're talking about the probate process a little bit. So Russ, if someone's going into probate, they're going to have to hire an attorney. They're going to have to open up this probate proceeding with the court. They're going to then, they've been named executor in the will, but the court has to then acknowledge that, and then there's going to be letters of testamentary, things that they're going to need to do with the attorney. Of course, the attorney's handling most of this for them. The expense of that, typically it takes about, what, a year to go through?
Yeah, 9 months or so.
If there's no issues or anything, right?
Yeah.
There's a filing that has to be done. Public notice has to be given. There's this whole process that you go through with probate. Now that part, and again, expense and stuff, and now let's compare that, and before, in going through that process, what is the ultimate goal? What are they, at the end of it, what have we accomplished?
Well, we're trying to get the assets transferred according to the will to whoever the named beneficiary is. But one thing that I always bring up to clients is the initial reason to go ahead and file the will is to pay the funeral home. And the problem with a will is that you cannot access accounts in order to pay bills until you get yourself appointed executor. So there's a delay there where you will probably be asking the person you name as executor to front the money to cover those costs and expenses. They'll be asked to front the money for the funeral home. They'll be asked to front the money to the attorney to file the petition. They'll be asked to front probate fees, court costs. And so make sure that you pick an executor that has a bunch of money in the bank, I guess, or large credit cards. Where they can view that. But I'm joking, but yeah, that is one of the biggest impediments to having a will, is that you got this initial delay process going on before you're able to access the assets. With a revocable trust, the person you name as trustee, all they need is a death certificate. And once they have a death certificate, then they can go to where you have accounts in your trust and have the bank acknowledge that now you're the successor trustee, and you can access those accounts almost immediately. And so to me, the initial goal is to get the expenses paid. Well, the trust is certainly able to do that much quicker with less out-of-pocket, forwarding of money or fronting money by the people you're picking to handle things for you. And then, of course, when you're going through and administering an estate, a lot of times, and again, I'm going pros and cons, you have delicate situations where you're trying to let people know or not know, or however you want to handle the distribution of your assets. You're wanting to do it in a way that's not so public. And the problem with the will is that when you file it at the courthouse, it's a public document. So anyone and everyone can go down there and read your will and decide, oh my goodness, I've been cut out as a beneficiary. I thought I was in this thing. I guess I'm just going to have to challenge it. Yeah. Well, with a trust, none of that information is public. It's all kept within the family, so how your estate gets distributed is never made known to the average Joe.
Or what you have.
Or what you have is known through the process. And then after the distribution of the assets, after you paid the costs and expenses and all that, then you want to distribute the assets to the family members or whoever you want to be as a beneficiary. Sometimes, again, the person you're setting something up for, they may have a spouse or significant other that might be curious as to how this estate plan is being put together. They can go down to the courthouse with a will and read a trust if that's how you're setting up an estate plan for a beneficiary. whereas a revocable trust doesn't provide that information. So there's a lot about it that helps keep it closer to the vest than with a revocable trust than with a will.
This is one of those areas when you're looking at your situation, understanding then what do you want to have happen? Do you like the idea of privacy? Do you like the idea that I can keep, whatever I have and whoever I'm leaving it to and what they're going to have and who they are? I'd like that to be private. I don't want it to be public. Well, the will is public, a trust is private. If you have assets in other estates, in other states rather, this is another area where you could get into multiple probates. You could have if you've got a place in Florida as well as here, you could have probate in Florida and probate here. You can double the cost, the expense, and deal with all that hassle as well. Do you like the idea, for instance, when you're, as far as ease of access? Do you want to have them have to go through a court process or get appointed and go through that before they can even access any funds? And if that were the case, do you have a plan to help them, in that short term but beforehand? Some kind of backup plan there. With a trust, again, it's much easier to allow that to happen. And at the end of the process, at the end of the probate process with the will, now the court is allowing that you can then distribute these assets out to whoever it is you've left it to. With the trust, again, you're able to do that up front. You don't have to have everything changed in a process of probate to allow it to be distributed. We do that up front with a trust. So when I meet with a client and we get with Russ, and Russ then does up their documents and we meet and do the signing, then they'll meet again with me and I will help them basically get the accounts in the name of the trust. Now, this doesn't change the way that you do your day-to-day. Doesn't change your, the way your bank accounts are set up as far as your checks, your checking account numbers, all of that stays the same. It's still under your tax ID number. You still file your taxes. Your day-to-day just goes along just as it would before a trust. However, with the trust, the only thing you'll see different is on your bank account statement, it'll have the trust name on it. And that's so important that we get these things set up either with transferring things into your trust or having your trust set up as a beneficiary of the trust, of the accounts as may be needed. Retirement accounts are so many different protections that come in through doing this. So even though it doesn't affect you during your lifetime, it sets everything up so if there's a period of incapacity or when you pass, everything's already lined up. There's no need for attorneys or courts or anything at that point. It's taken care of. So this is one of the areas of planning that can be so important to you. And Russ, when it comes to the trust piece, with people when they do get that set up and they have everything lined up and it's private now, they don't have anybody knowing what they have, who they've left it to. As we talked about with probate, anyone can go into, you can go in and look up the records of anyone. I used to do it actually just out of curiosity. I would go in and I'd go in and say, hey, where are the probate records? And they'd say in that file cabinet. You can walk over, you open the filing cabinet, and I'm thinking, well, I'm going to look for the thick files. I figure they got more stuff than the little files, right? You pull one out, and I mean, everything's in there. It shows me all the assets they have. It showed me who's receiving it, their address.
Yeah.
I'm like, man, this is like a prospecting list for a salesman. They could go through and call these people. Wow, you just inherited $1 million. I should probably talk to you about what you might want to do with that $1 million. I mean, these are the kind of things that you can avoid with a trust. So we're going to get into more now when we come back. We're going to take a break. When we come back, I want to delve into now that trust piece a little bit more and talk about some of the different areas, the different types of trusts within the trust, if you will, and some of the ways that you're protected potentially with that trust and some of the new trust law in Tennessee and how that can benefit you as well. We have some of the strongest trust laws protections basically in the country here in Tennessee. We're fortunate that way, and Russ is going to explain some of that to us as well. But first, a break. Join us here. We'll be right back on the Retirement Report.